Good morning. Just a brief opening comment. We're here for a hearing on the petition for rulemaking submitted by the Coalition for Fair Port Practices. Welcome to all of our guests, to the witnesses. Thank you for volunteering to testify. Thanks to the commission staff, so many of them, a lot of work to put all of this together. We have a full 2 days. I would ask the panel members, we need to stay on schedule for all the succeeding panels to come, so if we can stay within the 5 minutes and then give us time for what we hope is good dialogue between all of you all and our commissioners. Every member of the panel will have the opportunity to supplement answers in post-hearing written statements. And commissioners may, if they want, submit post-hearing written questions to panel members. So thank you, and turn to my colleague, Commissioner Dye.
Thank you very much. I have just a brief statement. My focus in the matter before us today is how ocean carrier and marine terminal demurrage and detention approaches can optimize, not diminish, the performance of the overall American international freight delivery system. As I said last month in my letter to the Commission transmitting the results of the Supply Chain Innovation Team's initiative, our international freight delivery system strains against the current demands placed upon it. Without a strong and dependable international commercial supply chain, the United States may not realize our greatest potential for robust economic growth and international competitiveness. I believe that the liner shipping industry, its customers, and the American consumer would benefit from addressing customer demurrage and detention issues in ways that maximize accessible and responsive customer service and minimize unintended consequences, of course. I also believe that we can agree that demurrage and detention processes should support prompt and efficient cargo delivery. Improvements to those processes may require closer cooperation and visibility among ocean carriers, marine terminals, and American shippers. I look forward to hearing the testimony of the witnesses today. Very much appreciate all of your being here and discussing the challenges regarding different carrier and terminal demurrage and detention policies and practices. Thank you very much.
Thank you. Commissioner Maffei.
Yes, thank you very much, Mr. Chairman, and it's good to see all of you. I do want to thank all of you, the witnesses, for taking time out of your busy schedules. We've got many distinguished witnesses, starting with this first panel, and I'm just thrilled that some of you traveled, and I think it is very important to me, to my mind, to be here in person and to discuss these issues in such an open forum. And so I think I join Commissioner Dye and the chairman and all of our staff when I say we really appreciate the enthusiastic response once these commission hearings were announced. And I do look forward to hearing what everybody has to say and getting answers to questions. From the outset, I've been a huge proponent of holding these hearings as a next step in the Commission's consideration of this important petition. Hearings are the ideal forum to encourage an open and transparent discussion about what is clearly a challenging and complex issue. I also believe that the hearings are important in and of themselves, since if nothing else, they will allow us to see if there is common ground among the parties. It is my hope that whatever the outcome of the petition, the Commission's involvement will act as a catalyst to help resolve these difficult issues facing the industry. And I am thrilled that the Commission moved forward so quickly with organizing and holding these hearings. And I particularly want to thank Commissioner Dye, former Commissioners Doyle and Cordero, and of course you, Mr. Chairman, to expedite these hearings and make sure that the Federal Maritime Commission is not seen as bureaucratic or sweeping any issues under the rug, but that we are going to consider things as they come as quickly as we possibly can. Finally, I would like to take a moment to thank the staff here at the Federal Maritime Commission for all the hard work they have done and put into this petition's consideration. We would not be able to hold these hearings without their hard work and dedication. And I thank you very much, Mr. Chairman.
Thank you, Madam Secretary. Would you proceed?
Thank you, Mr. Chairman. Good morning, Mr. Chairman, Commissioners. Our first panel today is going to be, I'm going to turn it over to Karen Booth in just a minute, but here with Ms. Booth, we have Nick DeMichael, Laura Crow, Don Pisano, Fred Joring, Robert Leaf, and Alex Charon. And at this point, I'll let you know that when you begin speaking, the panelists, I will put 5 minutes on the timer so you'll be able to see. At this point, I'll turn it over to Ms. Booth.
Thank you, Rachel. Good morning. Chairman Corey, Commissioner Dye, and Commissioner Maffei, on behalf of the Coalition for Fair Port Practices, we want to thank you for scheduling this hearing and for the opportunity to appear before you today to explain the unfair demurrage and detention practices that American businesses experience when our nation's seaports are congested or otherwise inaccessible due to causes beyond their control. In our testimony, the Coalition will explain the problems facing the many users of our nation's seaports with respect to demurrage and detention practices, and the relief that its many members are seeking from the Commission. And we hope to be able to answer all of your questions. As shown on pages 2 and 3 of a handout that I believe all of you have before you, the Coalition is comprised of 26 trade organizations who represent tens of thousands of American business across broad and diverse industry sectors, including large and small importers and exporters of retail, auto, food, meats, coffee, tea, chemicals, and other commodities. Motor carriers and drayage companies who operate at our nation's east, west, and Gulf Coast seaports, and logistics providers, forwarders, and customs brokers from across the nation, all of whom support the petition pending before you. Appearing for the Coalition today are 5 company witnesses and legal counsel. We would like for the company witnesses to provide their statements first. Then it will be followed by counsel's testimony. To the extent that a company witness uses less than 5 minutes, we would ask that the unused time be allocated to counsel. At the conclusion of all testimony, we welcome your questions. With that, we'd like to start with Mr. Don Pisano and the company testimony.
Good morning. I am Don Pisano, President of American Coffee Corporation. I am responsible for all operations, including all ocean-borne containerized shipments. Our company handles approximately 2,000 TEUs per year of green coffee beans from Asia, Africa, Central America, and South America into 15 ports of entry along all 3 U.S. coasts. While 2,000 containers probably puts us into the small to medium-sized shipper range, our span of activity gives us varied and pretty significant experience in dealing with carriers and marine terminal operators. From the experience, I must concur with most of the findings detailed in the FMC report issued April 3, 2015 on rules, rates, and practices relating to detention, demurrage, and free time for containerized imports and exports, in which it determined that there is no clear or standard manner in which carriers and terminal operators handle demurrage and detention issues, thus making comparisons quite difficult. While detention and demurrage charges are intended to encourage the timely pickup of containers from terminals and the timely return of equipment to the carriers, these charges are punitively applied in cases where it is impossible for the shipper to access the seaport due to congestion or other causes. While it is true that both terminal free time and equipment free time privileges may be negotiated with individual carriers, each carrier has its own policies regarding extended free time or waivers of charges, which are generally tied to larger volume commitments. Smaller shippers generally lack the ability to secure anything more than the standard tariff filings. We maintain service contracts with several major carriers that do include free time privileges within the service contract terms. However, we are often in disagreements with our carriers and the terminal operators that serve them over the fair and practical application of those privileges, and are regularly frustrated at our inability to reach amicable settlements. Over the past several years, our company has suffered through service disruptions caused by labor disputes between carriers and stevedoring unions, which were totally beyond our control. In addition, our company and the draymen handling our containers have experienced many incidences of severe congestion at container terminals as a result of larger vessels, the bunching of port calls, and poor planning and coordination between the carrier and the MTO, all of which prevented the pickup of our cargo and return of empty containers within the allowed terminal and equipment free time privileges. In some cases, terminal gates were closed without notice while our truckers had already been dispatched and were waiting in line to enter the terminal. We have also experienced numerous delays caused by U.S. governmental holds, including customs, VACAS exams, and other examinations and inspections, which are not always completed within the free time period allowed under our negotiated carrier service contracts, and for which we were eventually charged demurrage. In a specific case included in my statement submitted in support of the petition filed by the Coalition for Fair Port Practices, our containers could not be removed initially due to a customs hold. But once the permit to transfer was received, we still had 2 days of free time remaining, but were unable to secure appointments at the terminal, which forced us into incurring 5 days' worth of demurrage charges. Neither the customs hold nor the lack of available appointments were within our control. Frustrated by the carrier and terminal operators' refusal to negotiate a resolution, we actually did enlist the FMC's Office of Consumer Affairs for mediation, but even the FMC's efforts was rebuffed. While we can choose our carriers, it is a carrier who chooses the marine terminal operator. In the current environment, with the proliferation of vessel sharing agreements, there is no longer any real expectation as to which terminal will handle the cargo. Considering there is no commercial relationship between the beneficial cargo owner and the marine terminal operator, the MTO is free to act with impunity without consequence to their business. Now, what the coalition is seeking is not to be relieved of demurrage and detention charges when cargo is not removed or equipment is not returned in a timely manner when those actions are within our control, since we all benefit from efficient carrier and port operations. Nor is it seeking some kind of advantage over the carriers or marine terminal operators. We are purely seeking an establishment of fair business practices which can be uniformly applied throughout the U.S. port system. Surely, the Federal Maritime Commission, in its role to ensure a fair and competitive ocean shipping environment, has the authority and the wherewithal to require that shippers are not unfairly penalized when access to the goods is denied for a reason which is beyond the shipper's control. We respectfully urge the Commission to take action to offer guidance to the industry as to demurrage and detention practices that are fair, reasonable, and consistent with the Shipping Act in such circumstances. Thank you for your time.
Hello, everybody. Hello, everybody. Thank you. My name is Laura Crow, and I'm the Senior Director of Global Logistics for Walmart. My team oversees the business. No? Okay, I'll try again. Thank you. Hello, everybody. My name is Laura Crow, and I'm the Senior Director of Global Logistics for Walmart. My team oversees the movement of merchandise from purchase order creation to the port of destination, and in the U.S. to the first distribution center. Walmart is globally the largest beneficial cargo owner, with a vast majority of the volume coming into U.S. ports and terminals. We strategically diversify our port usage, moving 35% of our volume through the West Coast, 24% of our volume via the Gulf, and 41% of our volume via the East Coast. As my testimony will show, despite our size, it's very difficult to leverage our volume to achieve business solutions in regards to demurrage. To understand why, I think it's important to look at the history of the industry and what has gotten us to this point. Historically, the beneficial cargo owner, or BCO, had a contract with the steamship line, and the steamship line managed the movement of the cargo, in our case, from onboard the vessel through outgate at the destination terminal. The steamship line managed the terminal relationship on behalf of the BCO, and the BCO did not have direct contract with the terminals. The steamship lines operated smaller ships and called terminals where they had either influence or a direct relationship. As the industry has changed, we are now in the era of ultra-large ships, mega alliances, where the steamship line calls different terminals and often does not have the relationship with those terminals to champion the BCO. Historically, we also had smaller vessels and more sailings calling a terminal. Therefore, the BCO, via the steamship line, had multiple vessels arriving each week with smaller amounts of cargo on each vessel. As the trend to larger vessels and alliances grew, the amount of sailings diminished and the amount of cargo on each sailing increased. Many terminals became congested, and the reality of outgating the cargo became more difficult. However, the amount of free time to get the cargo outgated did not increase, and it ended up creating a revenue stream for the terminals. The competition between ports and terminals does exist in some areas, but in many of the ports and terminals, there is no competition as they are state-run, creating only one option within that geographical area to receive our shipments. We have fixed assets in markets where the terminals and ports have exclusive control. In these markets, the terminals and ports do not appear to have a market incentive to reach agreements with Walmart or other users. They often defer to the ocean carrier because we do not have direct contracts with the terminals. And then that carrier approaches the terminal on behalf of Walmart. The carrier is told that the terminal will not change the demurrage policy. Additionally, these demurrage policies are not equitable to all stakeholders. For example, this year in a Southeast terminal, our average dwell was 2 days more than our free time. And due to exceeding the tariff dwell by just under 2 days, we incurred significant demurrage fees in the millions. But if conversely, if we look at that same Southeast terminal in the previous year, Walmart cargo dwelled on average 3 days less than the tariff-free time. But there was no benefit to Walmart for moving the cargo expediently, nor any consideration of this fact when we request mitigation of the current year demurrage fees. These terminals seem to have no economic motivation to change or engage with the BCO to find solutions. While we could work a contract on a separate demurrage policy directly with the terminal, as I've illustrated, where we're a captive user, we have minimal economic leverage. Conversely, on the West Coast, which by all accounts have more congested terminals, there is competition, and the terminals actively work with Walmart in order to have Walmart choose to route the cargo via that terminal. We still run into issues with lack of appointments or cargo not being available, but we can contractually manage these issues with the steamship lines and interact directly with the terminals. The issue of demurrage is important due to the amount of money that is involved. In 2016, our cargo was pulled from the terminals on average 2.5 days less or shorter than the free time. In 2017, our cargo was pulled from the terminals on average 1.5 days less than the free time. But the difference of 1 day in charges between 2016 and 2017 are in the tens of millions of dollars. This is a troubling trend that is due in large part to increasing port congestion that is outside the control of Walmart. We believe that there is a market failure at certain ports and terminals in this country. This failure results in unnecessary costs to both businesses and consumers. For this reason, we support the petition before the Commission and would welcome guidance on problematic demurrage policies. Thank you for your time and consideration.
Good morning. My name is Robert Leaf, and I am the Senior Vice President for the East Region of Containerport Group. Since 1977, I have been involved in ocean transportation, first with U.S. Lines, then as a drayage carrier owner for 20 years, and now with Containerport Group. Containerport Group is one of the oldest international drayage companies in the United States. Our network of 20 terminals are primarily in the Midwest, Ohio Valley, Gulf, and East Coasts. I'm responsible for all operations for our terminals from Buffalo, New York to Savannah, Georgia, including all port and rail cities. In my capacity, I daily deal with truck drivers that complain about excessive delays and turn times at the various marine terminals at our nation's seaports that are caused by circumstances beyond our control. Our operations team report to me the significant demurrage and per diem exposure we have due to delays and the limited hours of operations. Our company in 2017 spent approximately $369,000 for detention, per diem, and demurrage charges, the substantial majority of which were due to delays and caused by delays that were beyond our control. As explained in my statement submitted in support of the Coalition's petition, in 2014, 2015, and early 2016, CPG and the independent contractors who haul on our behalf experienced port delays caused by labor disruption, weather, road construction, chassis shortages, systems failures, and port congestion. Despite the various factors that were beyond the control of the motor carrier, many vessel operating common carriers and marine terminal operators still assessed both per diem and demurrage fees in accordance with the UIAA and the marine terminal's operating schedules. Specifically, I explained that we have been charged per diem in situations where containers were returned within the allotted free time to the rail ramps in Columbus, Ohio, and then railed to the port of Norfolk, Virginia, which was closed due to a snowstorm. The vessel operating common carrier insisted that CPG or another party was liable for per diem incurred while the unit sat at the closed port. In another example, we were assessed substantial per diem during the heavy port congestion in Norfolk caused by the winter storms in 2015. When we disputed the charges, the vessel operating common carrier rejected our dispute, stating, "We do not waive per diem due to congestion. We encourage the truckers to email for the last free day so they can plan ahead. The best I can do is offer you a payment plan for the invoices because unfortunately you will get shut out." Today, the World Shipping Council and the National Association of Waterfront Employers indicate that congestion and associated detention, demurrage, per diem issues are no longer a problem or have subsided, thereby rendering the relief sought by the petition moot. This is not a true statement. Based on my experience, and the coalition has demonstrated, port congestion and other events impeding port access have occurred periodically for many years and will undoubtedly occur again. For example, the Port of Baltimore was frustrating during 2017. In February, delays for reasons out of our control started when turn times were exceeding 4 hours. The delays increased throughout the year and resulted in significant demurrage and detention charges for delays out of our control. The ocean carriers and terminals claim that commercial negotiations can address concerns over demurrage, detention, and per diem. However, that's not been my experience. As I have stated, in some cases, the carrier refuses to negotiate. In other instances, where issues are eventually resolved, the business owner has already incurred significant loss of time, resources, and efficiencies, which translate into lost revenue. This hurts American business, and all the more reason the FMC should step in and help address unfair demurrage, detention, and per diem practices. Also, it is apparent that the port congestion and related demurrage detention issues have become heightened in recent years, due in part to the snowball effect of substantially larger vessels. In 1977, when I started my career at U.S. Lines, the largest vessels carried 1,210 TEUs. During that time, Howland Hook Marine Terminal in the Port of New York, New Jersey had hours of Monday to Friday, 7 a.m. until 4 p.m. Today, in the Port of New York, New Jersey, we have vessels that are over 10,000 TEUs in size, yet the majority of the marine terminals still maintain the same hours of operation, Monday to Friday, 7 to 4. While ports have attempted to solve these problems through commercial negotiations, my experience is that these efforts are not sufficient. For example, during the summer of 2013, the Port of New York, New Jersey experienced severe congestion because of a variety of problems. They included labor shortages, operating system failures, a shortage of chassis, construction, and other related issues. The port also experienced a severe winter with record snow and ice and sub-freezing temperatures. In 2013, the Port Authority convened the Port Performance Task Force in an effort to solve the congestion issues. The task force was comprised of representatives from labor, marine terminal operators, ocean carriers, railroads, truckers, intermodal equipment providers, maintenance contractors, beneficial cargo owners, 3PLs, and the New York Shipping Association, and the Port Authority. In June 2014, the group issued a report, but despite these efforts, 3 years later, we are still faced with the exact same problems that were identified in 2014. It is time for the Federal Maritime Commission to help address this situation and implement guidelines for everyone to follow. I thank the Commission for holding this hearing and for the opportunity to share my views on this important topic.
Good morning. My name is Fred Joring, and I'm the president and owner of Golden State Express and the chairman of Harbor Trucking Association. Golden State Express operates roughly 30 trucks in the port of Los Angeles and Long Beach. The Harbor Trucking Association is a coalition of Los Angeles, Long Beach, and Oakland intermodal carriers whose purpose is to advocate, educate, and promote strategies with other goods movement stakeholders and policymakers that will provide a dialogue for intermodal truck efficiency. Today, I will cover several key issues in regard to the extreme port congestion that resulted in the unfair assessment of demurrage and detention charges of more than $100,000 to our company alone over the 2014 and 2015 time period for causes that were completely out of our control. A number of these problems continue today in various contexts. First, some facts. In 2013, before the congestion created by the West Coast labor negotiation and port slowdown, the 30 trucks operated by my company handled more than 12,000 loads to and from the port. And the average turn time for a truck in the San Pedro Bay port was 69 minutes. In 2014, the same amount of trucks handled just 8,308 loads with an average turn time of 112 minutes. And in 2015, these same trucks were able to complete only 5,615 turns at an average turn time of 89 minutes. But even since then, turn times have not returned to the numbers we experienced prior to 2014, a sign that congestion at the ports is a continuing and growing problem. For example, driver productivity, which was 3 or more round trips a day in 2013, has dropped to between 1 and 1.5 round trips after the slowdowns of 2014 and 15. This means that it's impossible for drivers to achieve the number of turns necessary to move the necessary volume from the terminals during the allotted free time. This past and ongoing congestion has created large amounts of detention and demurrage charges. We've been assessed tens of thousands of dollars in demurrage and detention over and above the cost to us of missed appointments, dry runs due to congestion and inability to complete transaction in the time necessary, and for causes that were completely beyond our control. The system makes it impossible to be treated fairly. For example, free time, typically 4 working days, is counted whether the container is available or not. And demurrage and detention must be paid before the container can be removed and often before the appointment can be made. The fact of the matter is that it's virtually impossible to pick up and drop off many containers in the allotted amount of free time given before the assessment of demurrage and detention. Finally, terminal operators have claimed that carrier and terminal competition makes it possible for importers and draymen to choose their carriers and terminals based on their free time, demurrage, and detention rules and practices. But while draymen often suggest to importers which terminals they prefer, in reality, only a very small minority of importers have the influence to require a carrier to discharge their goods at a particular location. In a large majority of the cases, the steamship line contracts with the terminal based on their own criteria. I would ask the Commission to look at these practices as unreasonable. It's our opinion that the process of assessing demurrage and detention is broken and outdated. We would urge the Commission to take measures to reform this process in a way that does not allow large foreign national companies to put small American companies out of business, which is what happened to many of my colleagues during the slowdown of 2014 and the Hanjin bankruptcy. Thank you for your time.
Honorable Chair and Commissioners, I want to thank you for this opportunity to testify before you today. My name is Alex Charon, and I currently serve as the Executive Director of the California Trucking Association's Intermodal Conference. Our membership consists of over 250 trucking, drayage, and logistics companies doing business in ports throughout the state of California. Together with our friends at the Harbor Trucking Association, represented here today by Mr. Fred Joring, who just testified, and their CEO, Weston Labar, who's in the crowd, we represent nearly 60% of all drayage and port-related trucking activity at the ports of Los Angeles and Long Beach, the nation's largest seaport complex. I also want to note, by way of context, that prior to my role with the CTA, I had the honor of serving as the Managing Director for Trade Relations and Port Operations at the Port of Long Beach. In both of these roles, I have come to learn that the issue of port-related congestion generally, and congestion impacting the ability of drayage operators to facilitate the pickup and delivery of cargo from marine terminal specifically is complex and multifaceted. However, what remains clear is that the Federal Maritime Commission is uniquely positioned, more so than any other government agency, and certainly more so than any other commercial concern, to set guidelines and a common understanding of what is fair and not fair in terms of the business practices impacting detention, demurrage, and per diem, some of the byproducts of port-related congestion. For that reason and many others, which you'll hear about today, the CTA Intermodal Conference strongly supports the request contained in the subject petition before the FMC to issue a policy statement containing guidance and specific standards regarding the issuance of unreasonable detention and demurrage practices by ocean carriers and MTOs when the charges are assessed for port delays that are beyond the control of the shipper, receiver, or drayman. Much to your relief, I'm sure, the CTA is not asking you to solve port congestion here today. However, for too long, certain operational practices at the ports of Los Angeles and Long Beach, by example, have left draymen with no other option than to ask for the assistance in issuing these guidelines. From intermittent and inconsistent gate openings and closures, lack of adequate notice to supply chain members regarding hours of operation at certain terminals, onerous requests for the repositioning of chassis and other equipment, lack of available appointments, and understaffing of labor by MTOs, congestion has left the local trucker and his or her BCO customer to foot the bill for charges caused by circumstances well out of their control. While a commercial solution may seem appropriate, I can assure you we have tried and tried again. I can recall, while on the Port of Long Beach executive staff, convening a meeting of local stakeholders to talk about the very issue we're here to talk about today. That meeting was in 2009. Subsequent to those efforts, there have been dozens and dozens of meetings, roundtables, stakeholder committees, some facilitated by the ports themselves, some facilitated by various members of the supply chain, and even some facilitated by this commission. While those discussions have shown to be fruitful in nurturing and furthering the relationship between truckers, MTOs, and others, the core practices of charging detention and other fees when inappropriate remains. Despite our appreciation for the involvement of various agencies, from the State of California Assembly Select Committee on Ports to the Port of Los Angeles and Long Beach stakeholder roundtables, I remain convinced that the FMC is the only entity that is positioned to effectively referee this issue addressed in the petition. The current assessment of detention and demurrage is imposed by one entity among many in a supply chain, and that entity has a vested financial interest in the operation of the terminal gate. That is to say that as long as only one entity among many in the supply chain serves as the gatekeeper for cargo, when and how a container can be picked up, that entity will always do what's in its best economic interest first, and what is in the best interest of the supply chain's efficiency second. This commission need look no further than the current administration of the Pier Pass program to see this. While we understand the impact that downward pricing pressures have on the goods movement industry, members of the CTA and other drayage entities remain convinced that as long as MTOs, and not a neutral agency like the FMC, set the guidelines, those guidelines will be skewed to one supply chain member's benefit and to another's detriment. That is why the CTA and others are asking this agency to help. On behalf of the California Trucking Association, we respectfully request that the FMC issue a policy statement as requested in the petition, setting clear guidelines and rules for all of us as to what constitutes unfair business and operational practices when it comes to charges from detention, demurrage, and per diem. Our trucking industry is willing to pay those appropriate and necessary charges borne by our missed appointments or poor planning, yet asking for consistent gate hours, a reasonable appointment structure, not to be burdened with wasteful equipment repositioning so that we can pick up cargo in a timely and efficient manner for all of our mutual customers is not a heavy lift in our collective opinion. I want to thank you for your time and look forward to answering any questions you may have.
As the commission has just heard, American businesses have experienced unfair demurrage and detention practices when the causes of port congestion and delays are completely beyond their control. These practices directly conflict with the very purpose of demurrage and detention, as described in long-standing commission precedent. And that is, demurrage and detention are charges that are intended to incentivize the timely removal of cargo from terminals, and the timely return of equipment. But when a port is inaccessible, preventing the removal of cargo or equipment return, it is unreasonable to penalize the shipper or drayman in cases where they have no control over the cause and no power to address the delays. The issues raised in this proceeding do not concern only past events, as you have just heard. Rather, larger vessels offloading increasing volumes of cargo at our nation's seaports, labor disputes, hurricanes, and snowstorms have created severe congestion in the past and will likely do so again in the future. The Commission itself recognized demurrage and detention practices assessed during port congestion as a serious issue during its 2014 field hearings, and its staff issued its own report on the topic in 2015. In that report, the Commission identified options for BCOs and draymen to consider to address the issue, including petitioning this Commission for a rulemaking. The Coalition carefully evaluated those options, which led to the filing of its petition and request for the Commission to take action to help address this problem. American business depends on competitive and efficient ocean transportation. The lack of any standards as to what constitutes unreasonable demurrage and detention practices leads to unfairness, which undermines the integrity and efficiency of the U.S. ocean transportation system. We are here today to reaffirm the Coalition's request for the Commission to exercise its authority to address this problem by issuing a policy statement that interprets existing requirements under the Shipping Act that prohibit unreasonable demurrage and detention practices. The Coalition strongly believes that an FMC policy statement would help eliminate confusion over proper demurrage and detention practices. It would eliminate many demurrage and detention disputes, and it would help facilitate commercial solutions. With that, I'd like to turn it over to Nick DeMichael, who will address why relying solely on commercial solutions is not adequate to solve the problem.
Members of the Commission, as noted on page 6 of the handout which we gave to you, carriers and terminals have claimed that existing commercial arrangements can adequately address the problem. We respectfully disagree. Labor problems and other congestion-causing events occur with regularity, but it has become increasingly clear that the market has not been able to come up with fair demurrage and detention practices in cases where the causes of delays preventing the movement of containers are out of the control of the shipper or drayman. Indeed, some of these problems, such as congestion caused by the use of larger vessels, as you've just heard, have increased. In most cases, terminals and carriers are in the best position to address port delays and congestion, not the shipper or drayman. Shippers and draymen do not have the ability to solve labor disputes. They don't control the loading and unloading of vessels or terminal appointments. They can't control even snow removal after a storm. Yet, when these delays occur, carriers and terminals typically still demand payment of demurrage and detention up front to secure the release of cargo, even when the very purpose of the charges to incentivize the timely removal of cargo can't be met. The lack of any regulatory guidance on the reasonableness of such practices results in substantial confusion, obfuscation, denial, and delay. Experience has shown that relying solely on commercial solutions in these matters leads to major inefficiencies, as parties must address whether the payments were proper after the fact. Many shippers and draymen, and even larger ones, do not have often the commercial leverage to negotiate contract terms to fairly address the problem. But another very significant barrier to effective commercial solutions is that shippers and draymen lack contractual privity with the terminals, but they rather negotiate with the ocean carriers. This structure often impedes the effectiveness of BCO carrier negotiations, since the terms are set by the terminals and those dictate what the VOCC is willing to negotiate. The status quo hurts American business who depend upon an efficient ocean transportation system and is flatly inconsistent with the policies of this administration, which seeks to promote fair business practices for American companies. Karen will now address why the Commission should step in to help industry address these unfair practices.
Thank you, Nick. As indicated on page 7 of the handout, the Commission is empowered under Section 41102 of the Shipping Act to ensure that carriers and terminals establish just and reasonable regulations and practices relating to the receiving, handling, storing, and delivering of property. It has long been established under Commission precedent that free time and demurrage detention fall within this prohibition. The Commission's authority to issue guidance as to unreasonable practices under 41102 is clear and unequivocal. However, the ocean carriers and terminals have wrongly claimed that the proposed policy statement asks the agency to prescribe commercial tariff rules, and that the Commission lacks that authority. This is nonsense. Unlike the 1946 New York Rules case, nowhere does the policy statement prescribe the number of free time days or the level of demurrage and detention charges that must be included in tariffs. The opponents wrongly conflate the statement's interpretation of an unreasonable practice that may occur during port congestion as a prescription of reasonable free time and demurrage and detention tariff rules. The very wording of the policy statement belies this claim. The Commission is the only party empowered by Congress to address unfair business practices employed through detention and demurrage charges. The Commission and its staff have the expertise needed, and we have faith in your abilities to craft a policy statement that can address this problem in a proactive manner, rather than through binding regulations. Thus, we strongly urge you to exercise this authority. And now Nick will specifically address the Coalition's policy statement.
On page 8 of your handout, you can see that the Coalition is requesting the Commission to issue a policy statement that would interpret Section 41102C to mean that when an ocean carrier is unable to tender cargo and such disability is beyond the control of the shipper or drayman, then it would be unreasonable to fail to extend free time or charge penalty demurrage. The requested policy statement, if you look on the handout on page 9, is consistent with the carrier's common carrier obligation as well as some existing commercial practices. You'll see on that page 9 that CMA, Costco, Mayer Terminals, and the Port of Long Beach all publish tariffs that extend free time when the carrier is, for any reason, prevented from tendering cargo or cargo cannot be loaded at the terminal. The rules of these good actors, and we appreciate this, indicate that the requested policy statement is consistent with some existing commercial practices, but the policies of these good actors are far from universal. If you look on page 10 of the handout, you can see the Coalition is asking for the issuance of a policy statement and not a binding rule. The wording of the proposed policy statement states that its purpose is interpretation of the statute. The wording is similar in form to wording that the agency has used for policy statements or interpretive rules it has issued in the past. The distinction between a policy statement and legislative rule is crucial. A policy statement is not a binding rule that can be enforced through civil penalties. Rather, any person who believes that the carrier or the MTO is acting inconsistent with the policy would have to file a complaint with the agency. And in that complaint, the agency would then have the power to examine individual facts and circumstances to determine if the carrier had acted unreasonably. Yet, the policy statement would give broad guidance to the industry, indicating how the Commission would likely exercise its discretion in the ordinary circumstance. The policy statement would therefore incentivize carriers and MTOs to adopt reasonable demurrage and detention rules. Thus, the issuance of a policy statement is consistent with this administration's focus on deregulation, since it would not be a binding legislative rule and would help the efficiency of the marketplace. Karen will now address the flexibility inherent in the policy statement.
Great, thanks, Nick. In the Commission's press release announcing this hearing, Chairman Corey asked whether the Commission could craft a general rule given the wide variety of commercial terms and disparate operating protocols at our nation's seaports. The answer to these questions is yes. First, we do not seek a binding legislative rule, as Nick just explained. And because a policy statement is a statement of general intent that industry can use to self-govern demurrage and detention practices, it must be applied based on the individual factual circumstances, particularly with respect to this one issue, whether the port delays are beyond the control of the shipper or the drayman. Thus, it is designed to be flexible and not a rigid rule. Second, the policy statement does not dictate the specific terms of service contracts or tariffs, quite the opposite. It allows for a wide variety of commercial terms because it does not require adoption of a specific free time period at any port. It does not dictate the arrangements for cargo pickup, and it does not set the level of demurrage and detention charges. Similarly, the policy statement allows for a wide variety of operating protocols at the ports. It does not say anything about how vessels are to be loaded or unloaded, how cargo moves through the port, how gate operations will work, or how any other port or terminal operations are to be performed. The requested policy statement focuses on one thing: the unreasonableness of levying penal demurrage and detention when it is impossible for the shipper or drayman to access the terminal to timely pick up cargo or return equipment, and where the very purpose underlying these charges cannot be achieved. I see my time is up. I'm going to wrap up here with our conclusion. We believe the Commission has a very comprehensive record already before it in this proceeding, which justifies issuance of the policy statement that industry can use to govern itself. Even though it was never required, the Coalition asked for a notice and comment proceeding as a procedural matter so that the Commission could get the very broadest of input as to the scope and wording of the policy statement. The Commission, if the Commission believes that any of the words of the proposed statement need to be changed, that should be addressed in the context of a rulemaking proceeding. The time to address this problem is now, before the next case of severe port congestion strikes. By proactively discouraging the use of unreasonable demurrage and detention practices and providing industry with the tools that it needs to more efficiently resolve demurrage and detention disputes. Thus, we very respectfully request that you grant the Coalition's petition and issue a policy statement interpreting unreasonable demurrage and detention practices under Section 41102 of the Act. And with that, we all would be very glad to answer your questions. Thank you.
Thank you. Thanks to all your comments. Where to start from different points of view. In your supplement, you say the supplement says that the proposed policy would reduce congestion. Can you help educate us on how the policy will itself is going to reduce congestion?
The policy statement is designed to address demurrage and detention charges during port congestion. And so that is the primary focus. But it will incentivize proper behavior on the part of terminals and carriers based on those policies to do the right thing and make sure that congestion is reduced. They have the power to address the causes of congestion, like Nick had mentioned. If there's a snowstorm, they're the ones that need to plan for the salt and the snow plows. If larger and larger vessels are being unloaded at the ports, they're the ones that have the power to address those issues. And this statement will encourage the terminals and the carriers to address those factors through ensuring that there won't be unreasonableness with respect to the free time demurrage and detention charges.
I would simply add that the present circumstance creates, in a sense, disincentives. If those things happen, the carriers and the MTOs can collect demurrage. Why do more? But if now demurrage is placed on, if demurrage can't be charged for things that the shipper and the receiver and the drayman can't be responsible for, that will incentivize those people who can do something about the problem, and that's what we want.
As an example of the disincentives, I had drivers sitting in line at a terminal the other night for more than 2 hours. During that 2 hours, their appointment expired, and the terminal refused to extend the free time or extend the appointment. Their answer was pay the demurrage, pay the pier pass, and get it tomorrow. So they've got the incentive to make it not work right now.
And that kept your container on the terminal for an extra day.
It did.
The general statement that if it's not the fault of the BCO interest, dray interest, then it reverts to the carrier being responsible. There are many situations where could we agree that they are mutually not at fault?
Yes, I believe that happens quite often. But the fact of the matter is that the demurrage charges are assessed at a punitive level as opposed to a compensatory level. You know, I've been in the business for over 40 years, and I have never once paid a compensatory level of demurrage. It's always at a punitive level. So when there is an act of God or a situation which is beyond the control of both the beneficial cargo owner and either the carrier or the terminal operator, those often situations do exist. But why should it be a punitive level assessed? It should be at something that would be commercially more compensatory for the use of their services.
Are we speaking in terms of the difference of stage 1, stage 2, stage 3 demurrage?
No, because I think stage 1, stage 2, and stage 3 are for time periods, correct? As opposed to the actual rate level of the demurrage rate for that particular day.
It probably depends on the tariff structure. I mean, I'm not a shipper. They would be in a better position to answer that. But I think, Chairman Corey, we tried to account for different types of scenarios in the policy statement, and it is broken into different sections. And I think Don was really describing what was Section D of the policy, essentially where there is a problem of whether or whatnot, where the drayman and shipper can't get their cargo due to factors that prevent them from getting into the port. And in those cases, it seems that a compensatory charge may be available. The facts and circumstances may put you under a different section of the policy. And it really, that's the whole point of the policy, which is to have some flexibility to it, depending on the timing of the issue. Is it, a pickup during free time or not? And depending on the circumstances.
I see, I'm going to allow myself an extra minute, if I may.
It's called chairman's privilege.
But you raise an issue that segues rather neatly into your petition in a number of places refers to the 1948 New York cases. And I think, the petition uses the words that you would like that they essentially, the petition and your purpose is to revive the 48 rules. In that case, and I'm not trying to get into the niceties, is it binding precedent, is it precedent, is it guidance, et cetera. Let's just say the commission has ruled in some of these areas for a limited geographic area. We all can agree on that. The commission then said, without turning it into a rate case, that initial first stage demurrage would be considered compensatory, and then anything else would be considered punitive. Can we, that is what the case says. Are you suggesting that we go to a totally different cost structure other than first stage demurrage? That's what I'm trying to understand, what you're asking for.
I do not believe that we are asking the commission to restructure and determine the number of tiers of demurrage precisely that would exist, the level of the charges that would exist. But from a policy perspective, we are asking the commission to look at these different scenarios and make some assessments as to unreasonable conduct, depending on the situations where there's no control over the BCO or drayman to access the ports. We, in hindsight, reviving those rules was an overstatement. The basis of that decision explains why those rules were necessary, and we have very, very similar conditions that happen to be occurring today, although for container traffic, not break bulk traffic. And so we do not want a prescription of the very specific terms, levels of charges, days of free time, et cetera. We want tools and guidelines to help industry self-govern itself. And in some cases, as indicated in the policy statement, a charge of a compensatory demurrage rate would make sense, but not a penal level, because the BCO and draymen still can't get access to their cargo, but there may be those situations under Section D where some level of charge still makes sense. And it should be more cost-based, although, we're not asking you to determine precisely levels of charges.
Section D of your petition.
Section D of the policy statement.
Yes, okay. Thank you.
It's very clear that the commission has the power to declare something unreasonable. And that's what we're, in a sense, asking the commission to do as a policy matter, as a guideline, to say that that unless you have this particular circumstance that we list in the B, C, and D section, if you don't do that, that would be unreasonable. The commission can't prescribe saying, okay, you have to charge $7.52, but it can say that $1 million charge is unreasonable, or it can say that some other practices are unreasonable, and that's well within the commission's power.
I'm going to close with this in terms of the 48 rules and cases that they examined a number of, and I'm just going to touch on one, something that Mr. Pisano, I'm sure, doesn't want to hear, but they looked at with some, detail, coffee and tea and other issues, and that commission held that the inspection was due to cargo, and that the allocation of risk for that delay did not warrant extended free time. So, that is where the prior cases came down, and as I said, I'm not going to go through all of the issues that the 48 FMC, guys with the Maritime Board then at that point went through. I'm going to relinquish my time that I've gone over, and I've used all of it. Commissioner
Curry,
Dye, should I just go to Commissioner?
Can I have a quick?
You know that's not going to work.
Can I have a quick response to that? I just
Sure.
wanted one quick follow-up to that point. I guess just two quick things. We recognize that customs exams, the level of control can vary, and there may be circumstances where there is some aspect of operations at the port that impact the timing of when that hold is released and what have you. Because of that, we specifically put language in the policy statement that would the only time that unreasonableness would happen or apply is where it's clear there's no fault of any kind on the part of the shipper, and that the shipper would not be in the stronger position to have control over the circumstance. So that is where, as Nick described, the policy statement is flexible, and it would require some taking into account of the specific facts. Just one last point is the Port of Long Beach itself has adopted a specific rule relative to customs exams where it does not start free time until the customs hold is released. And it seems to us that that's evidence of a reasonable practice, and it was something that we recognized and took into account in including this. We are not asking the agency to do something that goes well beyond practices that don't already exist.
And make no mistake, Mr. Pisano, as I listened carefully to your example, that then you had 2 more free days, and the port, as I understand it, taking facts as they were presented, said there were no appointments. And, you know, I need to stay on the good side of pre-deciding all cases, but that would certainly trouble me quite fundamentally. And so, Commissioner Dye.
So, Nick, it seemed to me that what you just described was actually guidance to our ALJs
Well, yes.
as they consider.
If a port or a carrier would charge demurrage for something that was completely out of the shipper's control, then what the policy statement would do, what would happen is a complaint would be filed, or could be filed, and then the ALJ would look at the policy statement to consider how the commission would, in general, look at a case like this. But the ALJ would, under the law, since it's simply a policy statement and not a binding rule, be able to say, first of all, there are facts and circumstances here that make it unfair in this particular case, or there is other circumstances for this particular case that policy statement should not be applied. And we could sit here and wonder all these kinds of circumstances that you may say, well, it shouldn't be applied.
Well, that's their job, to apply
That's
the facts.
But at least you would have, number one, the ALJ would have some guidance as to where the commission would in general look at this in the ordinary circumstance, and much more importantly, the carrier, the MTO, the shipper, the drayman would have guidance as to where this would go if it would get to that. And in all of these cases, people look at something like that and say, look, I can make a judgment here that I don't want to get into a big argument over this, and so let's just settle it. And that's what happens in 99.9% of the cases. It's only the cases where there is a real dispute as to who's at fault or what's responsible or all sorts of factual circumstances that might not be clear, would then parties go and do what the policy statement would allow, and that is to have an actual complaint filed. The reason why people don't file complaints now is there's nothing out there to let you know where things are likely to go. So the risk of filing a complaint is gigantic. The cost of filing a complaint is even more gigantic. So you just simply don't do it, and so things just keep on going the way they have been.
Thank you.
Commissioner, if I could just piggyback on that briefly. From the CTA's perspective, I want to corroborate what Mr. DeMichael just said. The reality is there are many alternative dispute resolution procedures available to truckers, but they all carry with them a tremendous cost burden. They all carry with them a tremendous operational burden. For someone like Fred running his business day to day, he has to make a commercial decision whether it's worth the time and money to see this dispute resolution through, which may put him back 6 months, 9 months, 12 months, depending on which agency he goes to. It would truncate that issue if there was some overriding policy where he could go directly to the MTO or someone else and say, you know where this is going. The FMC has set a guideline that says that there's an exemption for problems out of our control. It would really take a lot of the burden and the onus on the day-to-day operations of the truckers.
Okay, thank you. Thank you. I have three areas that I want to talk with all of our witnesses today. Of course, I've become an advocate for the freight delivery system. So I'm most interested in your talking to me about the effect on the systemic operation of our freight delivery system of these practices. And by the way, we have lots of team members, FMC Innovation team members here today. Thank you for your service to the Federal Maritime Commission. We appreciated the report. The report summary is available in the back for those of you who are interested. And we do believe that the National Seaport System, as we had worked on it, and I believe that the Los Angeles system is the only one who's actually pursuing that today. I would say to you, if your port is interested in that, run that down, because the essential pieces of information that would be available in that system would address this problem as well as what we hope is many others. Nick, it's been a long time since you and Karen and I talked about confidential service contracts, something like 1995 or something.
It was a wonderful time.
Yes, it was. Yes, it was. What is standing in the way of, I understand that not all shippers have the contractual ability to dictate terms, but what is standing in the way of service contracts handling these demurrage and detention approach problems? You've pointed out that there are some very worthwhile approaches.
Keep going.
That's for you.
I mean, quite honestly, we would love to be able to have a business discussion and leverage our volume, but our contracts are still with the carriers. And the carriers are then limited by what the terminals will give them. And then it comes down to, I want so much time in my contract, and then that ocean carrier has to try to negotiate with the terminal to get that time. I mean, we've had instances where the ocean carriers have come to us and said, can you help us negotiate with these terminals? Because they're not going to give us anything. So it's... Go ahead.
But they're the customers of the terminals.
Yeah, but I think once you're kind of locked in, once you have assets in that market, I've got one option, so they have no reason to negotiate with me.
Do they compete on these tariff practices? Do you choose based upon those approaches?
When I have options, so when it's a larger area like on the West Coast, we get very specific on how we choose what carrier we're going to use and what terminal our business is going to go to. It's not just the free time, but a lot of times it's, can I get access to the cargo? Can I get it off the terminal on time so I don't have to ever get to the point of paying demurrage?
Right.
But on the other side of the world where you have one port, one option, there's no choice for me other than to go there.
I see. Sure, Nick.
I could just add something, and I'm working from memory here, but I believe the Commission's April 2015 report talked a little bit about this and about contracts and the whole negotiation. But what that report said, again, working from memory, is that although you can negotiate service contracts for many terms, you don't often get negotiation for demurrage and detention. And
why is that?
The report was vague about why, but I think you've heard here from our witnesses, the reason is that this structure of the carrier, the shipper, and the MTO sort of off the side is the thing that is getting in the way of those things.
Yeah, we don't have that direct contract with the terminals.
Right.
So we just don't have any leverage with those
Right.
terminals to work deals.
Right.
I would like to add, if I may, that although we can negotiate what the free time periods may be, whether it's for the demurrage or for detention periods, to establish what would be determined as a disability period would be impossible, particularly for a small company like my own company, to try to negotiate. I've even had difficulty, trying to change the arbitration clause, allowing for the Federal Maritime Commission and Office of Caterers to hear the arbitrations. And, it's got to go to their head office, and it goes back and forth. I had only 2 carriers that were willing to agree to the arbitration clause for the FMC, and then the next year it disappeared, and I had to go through the whole process, and they said, no, we don't want to do that anymore. So.
Yeah. Yeah, you gave us a few examples here of carriers. Well, one terminal, our terminal as well. Are there other terminals, carriers, ports who do this well?
Who operate well or who will
Who-
contractually?
Yes, you would hold up as good examples for demurrage and detention practices.
Honestly, I hate to answer vaguely, but a lot of it depends on the year. You've got years where I can say, this year we had great business on the West Coast. We did not have a lot of problems there. Again, we choose exactly what terminals we want to use, and the Northwest, the Seattle, Tacoma, they've been great to work with too, really working with us, because the bottom line is we want our cargo,
Right.
that's what we want. And, if we can find ways to get access to our cargo, then the rest doesn't matter. But it's when we can't get that access, and those fees based on our volume aren't little amounts of money. And that's what we're really trying to do is I am completely okay paying a fee when I can't get my cargo. But that fee should not be punitive. It should be based on a partnership, because I want to get my cargo. Help me get my cargo. Don't just find me the few times I can, is what it comes down to.
Right.
And
Right.
of course, most of us can't determine what terminal to call.
Sorry.
I understand. So, Madam Secretary, how much time do I have?
As
I don't
much
wanna-
as you want, but
I don't want to, I just have one more area, and then I'll yield. In the event that there are disputes, we know from business research that the customer service employees who are empowered at the lowest level to resolve disputes quickly usually work for profitable companies. So can you tell me who has good dispute resolution services in this area? When there are charges and you want to work with the company to resolve them. So I'm not going to ask who is bad at it. Who's good at it?
I have an example where the Port of Long Beach actually stepped up when we had a situation that was very difficult, and they worked directly with us. They pulled in the third-party terminal where we were having challenges getting our cargo. And not only did they help us kind of get a resolution, they, facilitated, again, it's all about moving the freight, just let me move the freight.
Yeah.
They found the problem, and they worked with us to be able to find a solution. And, it didn't get to the point where, we had to call the FMC and say, hey, we're stuck. So I would say that was kind of one of our best examples.
Commissioner,
before or after Chairman Cordero.
It was actually
He's
after.
really on the ball out there, isn't he? Yeah.
Commissioner, I can provide just another small real-world example, and again, going back to the Port of Long Beach, because Commissioner Cordero is in the audience. Long Beach Container Terminal, I think if you were to poll local draymen, would say probably has the most efficient dispute resolution process. Coincidentally or not coincidentally, they also happen to have the most efficient gate turn times, trucker interface, and that is because there's a nexus with the capital investment that they've made. And I think if you were to canvass terminal operators and others throughout the country, you will see a direct relationship between the amount of investment they have made in new technology and infrastructure and the efficiency that they realize, at least in the eyes of the drayage community. And I think that spills over to the dispute resolution process as well. So we would ask you to look at Long Beach Container Terminal as a real-world example.
Thank you. Thank you. Thank you very much.
Thank you. Commissioner Maffei.
Thank you very much, Mr. Chairman, and thank you again to the panelists. I'll start with Ms. Booth and Mr. DeMichael. I think, to me, your arguments for a petition for additional action would have increased credibility if there had been many cases filed where a lack of such a policy statement caused either the case to be dismissed or unsuccessful due to lack of definition of unreasonable. Have there been such cases? And briefly, if not, why not?
Is your question whether or not there have been demurrage and detention cases brought to the FMC?
Yes. Why have no cases been brought under Section 10D1 of the Shipping Act?
Yeah, and I thank you, Commissioner Maffei, and I think Nick had alluded to this, and I think the business people can probably even speak more strongly to it, but my belief is that complaints have not been filed because there's no standard. It's the sheer lack of understanding about how the unreasonableness standard is interpreted that creates tremendous uncertainty for the businesses. And no business who's trying to get their cargo out of a port, and there's an immediate problem, take the time to hire lawyers, file a complaint, prepare a complaint, file a complaint, litigate a complaint that might take a year or two to get an answer without any standard. So it's the lack of clarity, it's the cost, it's the uncertainty and the time when there's an immediate business problem. And so,
But in other areas, such standards are established in court. So, when there's an interpretation of a particular word, I mean,
Actually-
they're established in court. I mean, I can understand that, but there are groups, there are trade groups that could bring a test case, for instance.
well, they can only do that if the business people think that the risk is worth doing. But I guess I would say that a sister agency, the Surface Transportation Board, very recently took on the issue of demurrage in a different context. And so they recognized the uncertainty dealing with rail demurrage. It was a different scenario than port congestion. It dealt with warehousemen and intermediaries, but it was because that those cases were more complicated, as is the case of port congestion, that the STB chose to take on demurrage. And they actually chose to issue binding regulations. That's not what we're seeking, as you know. But I think that was in 2014, and we'd be happy to get you a reference to that case. So I think other agencies have decided to take it on themselves.
I guess, but I think that is important, the difference between binding regulations and so-called guidance, what you're asking for, because let's say we were to go forth and issue such guidance, wouldn't it still be just as difficult for any of these folks to bring cases? They still have to bring a dispute case in order to have satisfaction here, and it's just as expensive, isn't it?
Well, Commissioner, if I let me respond to, I guess your earlier part of the question was, why haven't there been that many claims made to the commission before? It's because that we're dealing with this situation on a day-to-day basis. You're dealing with one container at a time, or two containers at a time, one bill of lading at a time. For me to interrupt my business and take time out of my business to make a complaint against a single container's worth of demurrage of $325, which I know should not have been assessed, or $235, whatever it is, that it should not have been assessed. It's not worth my while to dispute one individual.
But
if you're having multiple, it's like death by 1,000 cuts.
Yeah, but excuse me, the interruption. But why would it be worth your while if there was guidance? I mean,
first
you
off,
know, it sounds to me, particularly in many of the examples we read in the various comments, that these are cases where it's clearly unreasonable. And if it is clearly unreasonable, from like any observer's definition, us saying it's an example, you know, here's a guideline, it's unreasonable, you still have to bring the case. So it still could be, as you said, I mean, I appreciate your comment. As you say, 2 small potatoes, or in your case, coffee, to be worth the legal action. You'll still have to bring it, even if we have guidance. So,
Yes,
so
there
why
would
is
be-
that different?
There'd be much fewer instances where we would have this, because if you establish what is fair and what is reasonable, then the instances where you were not assessed something that was unfair or unreasonable would be greatly diminished.
Would it
and
be
that's
fair
why
to-
the establishment of a policy would benefit the entire industry, not only ourselves, but it would also benefit the flow of movement throughout.
So you
throughout
think the
terminal.
issue of guidance alone would be that deterrent?
Clearly.
Absolutely.
Fair enough. A question to back to you, Mr. Pisano, and Ms. Crow, is it Crow? Crow, who mentioned this, and anyone else, though, who wants to chime in. You talked about how these are punitive rather than compensatory charges. How do you know that? I mean, how do you know what the cost
I mean,
is?
frankly, it was designed that way. It was designed, years ago when they, as I said earlier, I've been in the business for a long time, and years ago you used to have 10 days worth of free time, and demurrage used to be at whatever, $60 a container or $50 a container. Free time took a dramatic change, or the assessment of free time privilege took a dramatic change, and went from, say, 10 days in the Port of New York to down to 4 days, and the increase of the demurrage charges went from what they thought was not really a punitive level, went from $60 up to $200, or to levels that were far more in excess of what the actual cost would be for the use of that thing. And I've used the example, people heard me say this, but I mean, I can park the container in a theater district in Manhattan a lot cheaper than I can at a terminal in Port Elizabeth.
Good. That's interesting. Okay, one other question. This gets back, I think, to a point that the chairman was making. But in your testimony, you talk about cases in which it is not the fault of the beneficial cargo owner that they can't get their container. And there are several examples in there. Are you saying that it is, in fact, the fault of the MTOs? Because there is a difference, I guess, between something that is equally not anyone's fault and the fault of the MTOs. And it would be helpful to me anyway if we could be honest about what you're saying. Are you saying that if it's whether it's a failure for labor disputes, to resolve labor disputes, or lack of organization, or refusal to open gates longer, is it in fact the MTO's fault? Are those the kind of cases that you're interested in?
What we're talking about here, and let me start some, and perhaps others can talk too, is we're talking about the purpose of demurrage to incentivize removal. And when that purpose can't be met because the shipper, for example, can't get there, then the whole purpose of the demurrage is frustrated. And so why should there be a charge in that case when the shipper or the drayman can't do anything? The second point is, we kind of talked a little bit about this before, I believe, with Commissioner Dye, that you look at something and you kind of say, okay, who can do something about this? And the party, is it the shipper or the carrier? Is it the shipper or the MTO that can do something about this? Is it the carrier? Is the drayman? Who is it? You shouldn't be putting the demurrage charge on the party who can't do anything about it. In most of these cases, it's the carrier and the MTO that can do something about it, whether it's the snowstorm clearing the port, whether it's investment in the port because you have larger ships now and you need to get the containers off quicker. So things that, in a sense, look like they are They aren't the fault of anybody. We're not saying that the carrier is responsible for the snowstorm, but the carrier can fix the problem much more likely. It's much more likely that the carrier is going to be able to fix or at least alleviate the problem much more likely.
What if we said, and this is highly theoretical, but what if we said it is unreasonable to charge the punitive charges, but it's still reasonable to charge compensatory?
The section D, actually, of our proposed policy statement says exactly that, that where the carrier can do what it's supposed to do, but the shipper can't get there, the carrier can charge compensatory. And so that's actually part of the section D of the policy statement.
Okay, one last question, at least for now, and this goes to Mr. Charon, who I know has mentioned this, and Mr. Leaf, and I think Ms. Crow has talked about this before. When we talk about LA Long Beach, the big impact of things like weather events and labor slowdown, meaning congestion, the delays caused by lack of hours of operation, the Pure Pass program was introduced as one way to address this. Do you think this has been an effective approach, and do you think it would be useful for similar programs at other ports?
I think Pure Pass, and I think I'm on record as saying this, and I know the Harbor Trucking Association as well, Pure Pass has been an effective way to, as an environmental program, and a way to divert truck traffic from the day to the night. However, our criticism of Pure Pass is the same as with detention and demurrage, and that is that one party in a multi-party supply chain controls the gate. And as long as you have that, they will always do, as I said in my statement, what's in their best economic interest first. And they will do what's best for the efficiency of the larger supply chain second. So much like our criticism of Pure Pass, asking for an independent body such as the FMC to issue guidelines and principles, our criticism would be the same of Pure Pass, and that is that for it to be effective and to regulate gate access, you have to have a neutral third party potentially administer that program.
Ms. Crow, do you want to add anything?
I would just say, I think when Pure Pass started, it was for a reason. Everybody was used to working on the standard day shift. And what Pure Pass did was it incentivized people to actually open their facilities in the evening and to work the evening hours. But if you look at kind of where we're at today, we have appointment systems, we have visibility systems that are interacting. The traffic is mitigated and regulated through the way the terminals are operating and how we're accessing our cargo. I don't know if Pure Pass, what it started out to do, is what it's currently doing.
Yeah, go ahead.
When Pure Pass was created, we were complaining. One of the reasons it was created was to mitigate the law that was passed that said that 30-minute turn times weren't being achieved. 30-minute turn times. And so its goal was, I thought, was to bring us back to 30-minute turn times. It has never gotten close. As a matter of fact, we're not even close to an hour turn times on average. I would say last month, without just guessing, our average is 89 minutes, and with a delta of up to 4 hours. And if there's anybody at fault for those turn times, it certainly isn't the trucker. It certainly is the terminal that controls the labor that pushes the turn times.
Okay, thank you very much, Mr. Chairman.
Thank you. Just two areas, and again, sake of time, et cetera, we may end up wanting to do a few extra questions, I think, post-hearing. But let me, while we're here, to explore two things. One, Mr. DeMichael and anyone else that wants to comment, I think when we keep trying to talk about, well, is it the fault of the American Coffee Corporation, or is it the fault of Walmart, and I could go on around the table, that we're not picking up this container, et cetera. Mr. Michael, I just have a little bit of concern with such a easy statement that, well, the carrier could plow the terminal faster. And where I'm going with this is when we get caught up with the concept of fault, does this sort of misdirect us in a way? Because I think perhaps should we focus a little bit more on at what point is the risk of certain things happening transfer from the carrier to the consignee. And as an example, I just have trouble thinking that during the labor disputes, I'll just use as an example, the labor disputes started in, how you count, July, definitely in August of 14, and then into starting to alleviate things, straighten out, and began in January, Feb of 15, that those carriers with 20 and 25 ships at anchor, paying crew, not able to tender their cargo, that was an efficient, money-making proposition for them. I think they would have much preferred, from a standpoint of efficient operations, in New York, coming into the harbor, and there's fog, and there's a snowstorm, and they have to go to an anchorage for the harbor master will even allow them in. That they accept that as their risk until the point in time comes that the container is successfully offloaded from the ship and it's landed onto the dock. And now cargo, you have 5 days to come pick it up. It's rather than fault, it's at what point does that shift of responsibility go to BCO, and then the snowstorm comes. And a part of what I hear is, well, at that point, we have a snowstorm, and now the risk of snow comes back to the carrier. Is that I'm being a little bit editorial to
No, I
frame
think-
up the discussion.
No, I think you're exactly right in this, but, and the thing that well, let me get back. The purpose of demurrage, going back through commission precedent for years and years and years, is incentivization to do something. And that's the thing that I think we need to focus on. Who is best incentivized to do something, and who is the party for that incentivization just doesn't work at all. So that's what we're kind of going to here, where the purpose of demurrage is to incentivize the shipper to move the stuff off. And I'm sure the port it's not happy at all for the port to be in a snowstorm or for the port to have huge congestion. But for the shipper has no influence over being able to do something about that in that case. And in those cases, the port or the VOCC has more ability, and so it's unfair, unreasonable for the shipper, looking at the purpose of demurrage, to be charged in that case.
And just one quick follow-up on that. I think that you talked about at what point does the risk shift, and it will vary under the circumstances, of course. But just to clarify, particularly under B of the policy statement, we do all need to recognize that there is a common carrier obligation to tender the cargo for delivery and provide a reasonable period of time for pickup. And it's in those cases where sometimes you can't even get in during the free time period, and yet the practice is to allow that to expire and then assess charges, where the policy statement would say the reasonable practice here is to extend because the carrier hasn't been able to complete its common carrier obligation under the law. And then the policy statement works down into other scenarios post-free time, and I think, Chairman Curry, you're kind of getting more into those where it can get a little gray or not. But I think Section D, I just want to be clear, indicates that we would not say that in all cases, the carriers and terminals should not recover anything. But in fact, compensatory demurrage should apply in those difficult cases where it's a more force majeure situation. Free time has already expired. The BCO couldn't get there for whatever reason or didn't attempt to during free time. And so I just don't want to get us bogged down into all the details of the policy statement, but I do want to state that it does try to address some of these factors as to timing, the carrier's legal obligation, and then force majeure where compensatory demurrage would apply.
Well, and if I can comment, I appreciate you using the term bogged down in the details. Therein is the exact problem that we struggle with from the commission standpoint is there are so many details, and having a simple unified rule for all 255 terminals around the country becomes problematic. Let me move on to the other one. So we're going to have to make a decision whether we go ahead and have the second panel before or after lunch. But let me ask for Mr. Pisano and any of the cargo interests here. You made reference to use the term infrastructure here in the U.S. to address your concerns. Many of the carriers have reduced down to rather small shops their U.S. interest. Can any of you all comment on not having carrier representatives with sufficient corporate authority to promptly, here in the U.S., to be aware of those situations, specifically in the ports that they're assigned to handle, and be able to timely respond to your concerns and disputes?
Well, I'd say that I have a recent situation where we've had an instance where we, maintained or put forward that the situation was beyond our control, and we tried to mitigate the penalty. And this was $10,000 on 3 containers that were held up, and completely due to customs and other issues, which were we had no ability to move the containers out. And it took, first off, I had to pay for it up front. So I had to pay the $10,000, or $9,500, I think it was, up front. And then it took about 2 months of contacting through my sales rep to try to get a resolution of the matter. And then they came back and finally said, okay, we'll give you a 25% discount on it. And this was something that was completely punitive and beyond my control, 3 containers. And I said, well, that's not acceptable. I said, you have to do something. And they came in, I said, well, can we split it? Can we do it at 50%? And it came out, 30% was the most that they would do. But I still haven't been paid. I don't have a credit on my books. I have, followed up on it about 6 times in the past 2 months, and it's in process. So this is just a typical example. I hope that answered your question.
I have a couple more questions, but I can submit those in writing.
I just have one more. Go ahead.
Well, just looking at we talked a little bit about weather, but just to focus in a little bit more on the government inspection, because actually weather, you brought up a good example that at least the terminal can do something about that or whatever, but government inspection really, actually, I mean, the terminals could argue that if anybody can do anything about that, it would be the kind of, it's because it's the kind of cargo that actually does have more to do with the BCO or the shipper. And, and if I, miss a plane because my bag was pulled at the TSA line and, I got there early enough, but there weren't enough TSA workers to inspect my bag and I missed the plane and the next one is just happens to be a more expensive flight. Is that unreasonable? No, of course not. So can you tell me a little bit more about what in these cases of government inspection, is it again down to simply that they should be able to charge compensatory but not punitive? Is that what we're talking about again? I just want to focus in on those particular issues of government, delays due to government inspections.
Well, I think that would be, something that could be considered as a resolution. But also, the fact of the matter is that it's the terminal operators that make the movement of and handle the control of the containers. And, whether that's due to their productivity. I know Customs has, can choose priority containers over others. But a lot of the movement of the containers to the inspection sites or to the VACAs site is actually outside of my control. It's totally.
I guess, but isn't it just a cost of doing business that they might, I mean, just like if I'm trying to get on this plane and I get nipped by TSA, what can I do? I mean, it's not the airline's fault. I mean, so isn't it just, part of, maybe it's an unfortunate world, but we all have to be safe. I mean, why necessarily should that be on, you know what I'm saying? I'm saying like, I understand an issue in situations where you can't get it because they can, but in this case, isn't it just shouldn't you just build in your business model that there's going to be some, some costs for those kind of containers in those situations, which should be fairly rare. I mean, or at least not, not the standard.
I would say yes. I mean, we don't expect every container, if that has a problem, to get out the gate. After free time, we understand we're going to have to pay some fees. We just want the fees to be not painful to pay, and we want to be able to feel more like a partnership in that, so we can have a conversation on it versus being dictated to that you must pay this a fee that we feel is unreasonable. Because we do budget for demurrage. We know we're going to have to pay some, but we want it to be a fair amount.
Commissioner, if I could just piggyback on that from the CTA standpoint and the drayman, I think we have no issue or problems if we miss an appointment or if it's our fault, and we also are cognizant of the fact that there are going to be government inspections, and I think we account for that. But that is a really de minimis percentage of the overall delay pie, for lack of a better term. I think most, if not all, of the delay that we reference and we talk about in our statement is decisions or activities within the discretion of the marine terminal operator.
Yeah, if I'm not saying you should have this, but if you have any data on the various reasons for delays, boy, we'd love to see that if you could submit it for the record.
Both the CTA and I think the HTA would be happy to provide some of that data in post-testimony comments.
Thank you, Mr. Chairman, for the added time.
Thank you. One last question I'd like for the panel to take for just a couple of minutes. As I've listened in my notes, I think every one of the panelists talked about appointment systems in one shape, form, or another. And this is something that has really grown over the last number of years. I go back to the 1948 case. They actually discouraged appointment systems. But now they are becoming more and more the way things are done. When you call during your free time, reason, and I'm not talking about on the 5th day at the 11th hour, but normal free time, and they say, sorry, no appointments until next week, and you say, but that's going to put me into demurrage terms, what do they say? I mean, I assume you're saying, but that's not fair, or stronger words. I sailed, I know that other language.
We have 12 terminals the last time I counted in LA Long Beach, and you probably get 12 different answers from them. The answer I got last week or 2 weeks ago on 3 containers that we were trying from Wednesday on to get appointments and couldn't get them was, sorry, pay the demurrage and come get them. The next appointment is Saturday. And thank God they were open on Saturday because it was only $675 instead of $1,800, $1,900 on Monday. But that's, again, very typical of what we're seeing on a day-to-day basis.
Because this is not snow, this is not anything else. This is an act, and as Ms. Booth and Mr. DeMichael correctly point out, the law says you have to tender it's a legal term, for 5 days. I mean, do you say, well, but you're not tendering for 5 days? What do they say? I'm sure there's some carrier interest here that realize that they're going to get some questions too, but
That's
what-
not an argument they'll even listen to. It's just not. I mean, it's so typical that they'll have it not available 2 or 3 days in that 5 days or 4 days. And the world goes on, demurrage goes on.
And there is a clause in the tariff statute that ensures that a tariff is actually an implied contract with users of the port. Some of us have talked about tariffs and tariff problems for also since 1995. But that is binding for that reason. Also, just one more thing and then I'm done. If you could give us some of the STB approaches in areas that you believe are like the things that we're discussing. Thank you.
Mr. Pisano, if next time you could bring some of your product to sell in the lobby, that's my only other request. I appreciate that. These are filled with water, unfortunately.
thank you to everybody in this panel. We did run over, but I think for good reason. This is the Petitioners Panel, and wanted to give them as full of opportunity to speak. We can talk offline as to if you want, what you want to do tomorrow. Unless the second panel wants to stand right now, feel free to raise your hand. I'm going to make a judgment call and say, let's go ahead and do lunch now and then do the 2 panels in the afternoon. Does that suit everyone? Peter?
Mr. Chairman.
A little earlier? Can we start earlier?
Yeah, I would recommend we start at 1 p.m. in that case.
1 p.m. it is. Excellent idea. Thank you again. Okay, thank you.
Thank you very much.
Thank you.